I think the last year that is on there is 2020, so you'll use the 2020 calculation. But parenting time is a factor in that. It's set by statute. The biggest part of determining child support is determining the incomes of the parties, and that can be kind of tough, especially when you have self-employed individuals. So if there's a dispute about that, that can be a big sticking point, is what is the actual income, especially when you have self-employed individuals who might be fudging their numbers or fudging their taxes a little bit and writing things off that maybe aren't quite business expenses. So that's one particular issue that can come up, and we'll discuss that a little bit later. So jurisdiction for minor children. This is a pretty critical issue, and this is something I ask of every client. You usually find this out when you're doing the information for the affidavit of minor children, is that jurisdiction is critical. The children have to have resided in Arizona 6 months prior to filing in most cases. There are exceptions to that, but in most cases they have to be, the children have to be present for 6 months, even though the parties only have to be present for 90 days. So you should be aware of that, and you can check out that statute. One thing that we see come up every once in a while is if one of the children was born prior to the marriage, the court wants to see a statement in the petition that that's the case, and that there is usually a copy of the birth certificate needs to be attached with that, so that they can determine that that's not a paternity issue and it is actually part of the divorce. But I've had seen that where that client has not disclosed that, or really I should be asking that question, and it's become an issue in the default where we have to provide that for the court to move forward with it. So just quickly through the process, just kind of, I don't want to get too deep into this just because there's instructions on the court website. I really like using the self-service center for some of this stuff because they do lay out this process in the forms very easily. So if you do have a question on it, if you run it, hey, what was the time frame on this, or what was the process for this, refer to that self-service center because those have really good instructions on how to do this. So the initial filing with the court is going to occur first, those initial filing documents. The next thing is service. So they can be served, generally speaking, in 3 ways. Through acceptance of service, where the respondent accepts service and waives their right to be served by process server, where they're just saying, I've received a copy of the documents. I don't necessarily agree or disagree with them, but I've received my copies. Certified mail, the key to this being restricted delivery, meaning it must be signed for by the addressee. It cannot be signed by anybody else. Or obviously a licensed process server. So a couple things, just a couple issues I want to bring up on acceptance of service. If the party is outside of the country, this can be an issue. The Hague Convention, which is what governs service, international service, does not allow for acceptance of service when the party is outside the United States. We've done this in the past, and we haven't had any problems with it, but if you get a commissioner who is really sticky on this, that could cause a problem. So generally, if one of the parties is Canadian or from Mexico, or we had one that was in England recently, usually they need to be served via process server that's certified to serve in the Hague, in accordance with the Hague Convention. And you can look that up online, Google the Hague Convention, and usually most process servers have that on their website. So something to be aware of. And the other thing with acceptance of service is there was a rule change, a lot of you remember this, in 2019, that changed the rule that the service has occurred when there's an acceptance of service that's being used. Service does not occur until the acceptance of service is signed and notarized by the party and filed with the court. So the service date is the date of filing with the court, not the date that the respondent signed the document. Okay, any questions on that? I'm kind of neglecting the chat here. I'll get back to some of these questions here in a minute. But so this date it's filed with the court. Certified mail is the date that it's actually certified. One problem with certified mail is, number one, sometimes the parties won't sign it, but number two is The biggest problem we see with it is the post office doesn't fill out the return receipt correctly. They leave off the name of the person who signed it. They leave off the date that signed it. And then you're having to do it all over again. Clients paying out more money and things like that. So I kind of make them aware of that expectation. Process server is pretty straightforward. Just send the documents. Probably a best practice on process servers is when you get the affidavit of service back, just to make sure that they have listed all of the required documents in there. Every once in a while, I'll get one back where they've left something out, and that can cause a problem later on. So once they're served, there's 20-day waiting period if they're in Arizona, 30 days if they're out of the state for them to respond. If they don't respond in that time frame, you can file the application and affidavit for default, which is basically a document that says the respondent has not answered or disagreed with the petition. We're asking the court to move forward without their response. After that, there is a 10 business day or 10 court day waiting period after that. And then once that period has passed completely, which really equates to about 12 business days, then you can set the default hearing or call and set a hearing. If you're in Maricopa County, you can call and set the hearing for them. If you're in Pinal County, they will need to call and do that themselves. If it is a default hearing, right now the process is you have to deliver 3 copies of the decrees or any orders, child support orders or legal decision-making plan, or not legal decision-making plan, but the child support orders, income withholding orders, along with addressed stamped envelopes for each party to the judicial officer at least 5 days prior to the hearing. I do it the second I set the hearing. Those get sent to the court or delivered to the court. Okay. Any questions on that? On that part of it? Let me kind of go through this. So let me go back. There was one question about children born out of wedlock. If the birth certificate does not have the father's name on it, how do you handle that? Well, in that case, you're going to have to, if there is no father's name on it and there's no, the father can sign an affidavit saying that he is the child's father, or that he accepts that responsibility, I guess, that can be signed by both parties. That's one way to deal with it. The other option would be to get the parties to sign a consent decree together as part of it, saying that, hey, we agree. Yeah, he's not on there, but here's this affidavit saying he's accepted, for lack of a better term, appointment of fatherhood on that. And so, yeah, so that hopefully that answers your question, Suzanne. The same rule apply for process servers. Oh, let me go back here. Same rule applies. The service day, this is a question, is the service day is when they filed the affidavit or when they served the opposing party. Process servers and certified mail, it is the day that they receive the documents. That is the date of service. It has nothing to do when they file the affidavit. I recently had a client who filed the acceptance of service, waited 20 days, and then filed the default and waiver of hearing. Judge kicked it back, the affidavit stating the acceptance of service was not. Okay. Yes, that I should have touched on that. Good point, Rosemary. When you file the affidavit, if there's an acceptance of service in the case and the affidavit, the application for default is being filed, that acceptance of service must be attached to the affidavit for default. If it's not, that is done by court rule. That is not a judge's, that is part of that rule change. That is not the judge's discretion. That has to be attachments of acceptance of service. I've taken the best practice of no matter what the method of service is, I attach that affidavit, whether it's acceptance of service, process server, or certified mail. I accept it to that. I attach it to that application for default. I have the rule. I have the general theory of you're better to over document than under document. And so the court doesn't mind if you over document. Generally, they do mind if you under document. So yeah, that's a good point. They do need to attach that affidavit, that affidavit of service to the application for default. For the party living in Trinidad, we cannot use certified mail. Under the Hague Convention, that's correct. They have to be served via process server that is certified to serve under the Hague Convention. This can be a problem, and we have done it with the application for default. or the acceptance of service, and we generally have not had any issues with it, but it could be. So you need to be aware of that. The Hague Convention requires a party outside the United States to be served via process server. Okay, so hopefully that answers that question. I thought I had one more that popped up here. And yep, that probably will be expensive. And process servers, and actually, you know, we did one in the UK recently and only cost $80. So UK is a little different though, so who knows? Okay, so we got that. Response. Okay, so this is what happens if one of the parties, when it becomes a contested matter. So one of the parties responds or files a disagreement with the court. Must be done in writing, has to be filed with the court. We had a client the other day whose wife called in to the court and said, I disagree with it, and they didn't even listen to her. So it's got to be filed, a response. Generally, my experience has been, even if they're outside of those waiting periods, that 20-day and 10 days, the court will generally accept that. We had a commissioner at one of these CE classes a few years back, and I asked her specifically about that. I said, what is the court's general practice on that? She says they accept the response and it moves to a contested matter at that point and cannot go through the default process. So just be aware of that. And now I don't know if there's attorneys involved, if the court will maintain that or not. There may be some stricter requirements if the attorneys are involved. So what happens when it happens? So the general idea is when someone responds to it or it becomes a contested matter, usually the first step is what's called an early resolution management conference. And essentially how I like to describe this is kind of a mini mediation at the court to check and see if the parties can come to an agreement. If they can come to an agreement, the court will prepare a consent decree right then and there. Takes a couple hours, but they will prepare a consent decree right then and there, or soon thereafter if it's all online at this point. And they'll divorce them right there. So the important thing to remember is that that conference is not going to take place less than 60 days after the party is served, the respondent is served. So you should be aware of that. Mary, do you have a question?
Yes, so I've seen a few of those lately, and they don't address the quadro, or they say that it needs to be submitted within 30 days, which is impossible. And it also does not address who pays for the quadro. So it becomes an issue, and then the parties have to turn around and hire somebody and add to the dispute.
Yeah, and that's something that we see a lot, even in judges' orders. I've come across several of them recently where the judge isn't specific about the quadro and how to deal with that. So it's something to make your client aware of so that when they go to those conferences, another best practice, I appreciate that make them aware of, hey, this is something that needs to be dealt with. If you come to an agreement on this, you need to make sure you deal with this quadro issue, who's going to pay for it, and how those things are going to be divided. Do you have anything else to add to that, Mary? Or
no, that pretty much does it. And again, be more specific in the language. There's one now, and I refer it over to an attorney, and they're now having to litigate because the language is ambiguous, and it was actually a judge who said it, and about the community property portion of the retirement.
Yep. Yeah, quadros, I'm going to get into that specifically. Quadros, the language in quadros and the language in the decree about the retirement plans is really critical in how that's worded, because you can really cause a problem if it's not worded correctly. So if, this is the short story of contested matters, and that is if they can't come to an agreement, there's a discovery period, just like there is in a civil litigation, and then a trial, where a judge will make the decision for them if they can't come to these agreements. And I say just like the movies, because it kind of is. Actually, I got called as a witness in a probate case one time. It was kind of a goofy situation, and the judge or the commissioner in the probate used that term. She said, I want to remind everybody this is a trial, just like it is on Law and Order. And said that in open court. I thought that was kind of a funny way to describe it. But now there is one other process that comes up, and this is a new process, and some of you may not be familiar with it. And that is, I kind of lost my, presentation here. And that is this summary consent decree process. So this is a new process that the court put into place early last year. And essentially what it is, it's where the parties are in agreement prior to the filing of the documents. And so what happens is the petition that's being filed, all of the other documents are still required. Preliminary injunction, credit notice, all of those documents are still required to be filed. But there's a particular change in the way the petition is done. And that is that the petition becomes the petition and the response. So it's normally there is just a petition and then a response or a consent decree that's filed. On this new summary consent decree process, it can be both, where both parties sign the petition and it becomes a petition and a response. And in that petition, and you can look up some of this language is actually in the self-service center form. So if you're looking for the language, you can look at that form and get the language. But it basically says this is the parties are in agreement. They intend to file a consent decree later on, which is a decree that both parties have signed by agreement, and that this is considered the petition and the response for the respondent. Acceptance of service still has to be filed with it when the parties are done, and it doesn't reduce the fees and it doesn't shorten the time frames really. So they have a petition fee if it's in Maricopa County, $349, and the response fee, which I believe is $289 or $279. I don't remember exactly what it is. So those will both be required to be filed at the time. The idea is to remove the uncertainty of the process, reduce the fighting. It's more convenient. There's no hearings. Once that 60-day time frame has passed, statutory waiting period has passed, the judge can sign it. It doesn't always happen that fast, but it never happens that fast actually. But it can be signed in that time frame. One important thing to be aware of is that there is one of the documents that's going to get filed with that is something called an intent to file consent decree. This says the parties are intending to file a consent decree later on, but that the parties acknowledge that consent or that intent can be withdrawn and it can move to a contested matter if something comes up and the parties change their mind. So it's not necessarily a set in stone kind of thing, and that's an important expectation to be set with your customers, is that is not necessarily a just because they file this document does not mean that they are that they're stuck in it and that the other party can't contest it. Is it in Maricopa? As far as I know, Maricopa County is the only one that's doing it at this point. That's my understanding. I don't know, Don, if you have any input on that, but as far as I know, Maricopa County is only the one doing this summary consent decree process. Is that your understanding as well?
Yeah, that is my understanding, but I'm not 100% sure of that.
Okay. So I guess you could probably ask the other court if they're doing that, but my understanding is right now it's just Maricopa County. Okay, so some of the more finite issues, some of the more detailed issues that come up in this are real property issues. When you're dividing real property, deeds are best, meaning the parties should exercise deeds whenever they execute deeds whenever they can. I've heard of some people relying on the decree to the final order by the judge to convey real property or interest in real property or primary residences, things like that, to the other party. This is a bad idea. And the reason is because the ultimate arbiter of these things as to who the actual owner is and who who owns all the interest is the title company. If you can't ensure title, you're never going to be able to sell a property. And the title companies are notoriously picky about this. At the very least, if that's what the client is just dead set on doing, the decree must state that the court is conveying real property to the other party and that it is an actual legal description in there. And the legal description meaning lot 5 of Stonegate Estates as recorded in Maricopa County Records, book 245, page 49 of county records. That is what the legal description needs to be. and you cannot use addresses. Title companies will not accept it. Sometimes they will accept the decree as a quote unquote deed. Sometimes they won't, but that language is critical. And so I, if you can't get them to sign a deed, then do the decree language the best you can in order to deal with that. But understand they need to have that expectation that might not work. Don, did you have something?
Yeah, a question. When I used to do this kind of work, I know periodically I would have somebody, either it'd be the client or the other party, that would refuse to sign the deed because they were concerned that may trigger the acceleration clause in their deed of trust. I don't know if you have any comments about something like that.
Well, I can tell you this, it will not trigger the acceleration clause. As long as the beneficial party does not change the bank, at least like if the party said, hey, as part of the divorce, we're going to give this house to my mom and there's a lien against it. Yeah, that could trigger an acceleration clause if one of those parties does not remain on there. Generally, from what I've seen is that they don't have any problems with that as long as at least one of the parties is the beneficial owner. One of the parties to the deed of trust, meaning the borrower, is still the beneficial owner. And this kind of gets into my next thing. Mary, did you have something, or did you have your hand up still from something?
I did, because this is another issue that comes back, and even attorneys are doing that. Use the legal description from the recorder's office and not the one that is on the tax statement or the assessor's office. That is not a true legal description. And you were exactly right when you were talking about the book number, the page number, and that will indicate you've got the correct one.
Exactly. Yep, exactly. Suzanne made a comment on the thing, if you're not following the chat. As I offer my clients the option of doing limited title search at the beginning, so you know if there's any upfront issues. Don't use a quick claim deed. Yep, those are all good practices as well. So I appreciate that, Suzanne. That's not a bad idea. So kind of, Don, this is kind of where I was going to go with this, is you can be pretty creative with the language in these divorces. And what I mean by that is I had a client who they had been married a long time. They were getting along really well. He wanted her to stay in the home, but he wanted to make sure that his interest in the home was protected and that her interest was protected and that the kids got to stay in the home. And so the paragraph dealing with real property was like almost a full page in the divorce. And it was basically, you can say it said she can stay in the home for up to 5 years. After 5 years, she either has to sell the home or refinance it into her name and pay him a set dollar amount based on an appraisal by a licensed appraiser that's hired for the purposes of the refinance. And that if they determine if she can't make the mortgage payment, she'll notify him. And it went on and on and on. So you can get pretty specific in these things if that's what your client wants to do. But it should be very, very, very specific as to how that's going to be dealt with. Because again, the court will enforce everything, or could enforce everything in the decree, and will not enforce anything that's not in there. So you can get pretty creative with some of that stuff on how that stuff gets dealt with. Let's see here. So we got through that. Tax issues on this. I'm going to kind of go a little bit quicker on this because there are some other things I want to get to. But tax issues, in the year that the divorce is finalized, meaning the judge issues the decree, you cannot file a joint tax return. This comes up all the time where they say, well, we've agreed, we're just going to file a joint tax return this year. Nope, you can't. That is set by federal law. If you are divorced on December 31st at 11:59 p.m. of 2020, you are divorced for all of 2020 in the eyes of the IRS. And so they need to be very careful, and that needs to be something that's dealt with in the decree as to how that's going to be handled and how taxes are going to be paid and refunds are going to be dealt with. Other things to be issues to think about on taxes, how refunds are going to be dealt with, if they're going to split equally. Oops. Sorry about that. If there's taxes that are owed from prior years or could be owed from prior years, or if there are unknown taxes that are dealt with, how the child tax credits are going to be dealt with. So that part of the parenting plan needs to say, or the decree needs to say, who's going to claim which children or child, what tax years. And the thing that's coming up lately that I'm starting to put in my decrees is stimulus checks. So how are they going to be dealt with? Because some of these stimulus checks are going to joint bank accounts or getting sent to one party, and all of a sudden that party is claiming ignorance or won't turn over the other party's stimulus. And it's come up several times this year. And so it's something that I've kind of put in there as, hey, if this happens in the future, this is how it's going to be dealt with. Something you might not be thinking about. We already talked about the spousal maintenance issue not being taxable or tax deductible for 2019 and later. Some common problems that we're seeing in dissolution. You can't locate the other spouse, or they've been separated for so long they don't know where they're at. Skip traces that are done with, usually most process servers offer this. They're usually like 35 or 40 bucks. You can get a skip trace done. They're pretty good. I've got about 85% success with tracking down a spouse with a skip trace. Social media is a really good way to do it. Even just Google, you'd be surprised at when I'm doing or estate planning documents and we need an address and they don't have the address, I'll just Google them. A lot of times I can find it. One of the other problems we see, not with our stuff, but with clients coming in with questions about why their divorce isn't going through, is the decree doesn't match the petition exactly. So in a default process, that decree has got to be pretty much identical to the petition in terms of how things, assets, debts, and kids. One of the big problems, Don, you kind of touched on this earlier, was this desire to get it over with, or the lack of detail. Or Mary, you brought this up in some of the final orders that the court is making, or the judges or attorneys are writing, that there's a lack of detail in some of these things and a desire just to kind of get the process over with, and they don't want to be real detailed with it because that's where conflict arises and things like that. And that can cause a lot of problems in that process. The other thing we're seeing is inaccurate child support worksheets. I'll ask the client, hey, what's your income for this year? It's like 30,000. And then they get to the default hearing and the judge verifies that. And they go, no, it's more like 25 or it's more like 40 or 60. And then all of a sudden they've got a problem. The judge is saying, well, why is this different from what you filed with the court? So they need to make sure they're accurate in that information that they're providing. I'm going to kind of go quickly through this modification thing. So some things any questions on that process, on the divorce or dissolution process, that initial petition process? Anyone have any comments or anything like that on there? If not, Mary?
Sorry, just real quick, any suggestions about the stimulus check? There's issues where the primary care parent feels that they're entitled to that check for the child, and yet non-custodial parent feels that they should get something.
This is such a new issue that my suggestion would be, if it's a prior order, yeah, the only thing you can do is ask the court to enforce it in the way that you would benefit your client in the way that they're asking. But if it's something you're going to put into a decree later on, that's specific how that's going to be dealt with. That, the parties are each entitled to like an example might be, each party is entitled to the value of their stimulus check, and that if there's a primary custodial party, they'll get the money for the kids, or if they'll split it 50-50, or they'll split it based on their incomes. That's something that could come up, and it's something that could come up in the future as well. We don't know how long this thing's going to go on, and so something to be dealt with, but it's so new. I spent quite a while Googling and looking for cases on this, and there's nothing on it. And so something that needs to be dealt with in a very specific manner. Okay. So modifications and terminations, we're going to kind of go through this real quickly. Some commonly modified orders be child support. That's probably the most common one. Parenting time, legal decision-making, when the parties need to change the way the legal decision-making is done. And sometimes the decrees need to be modified. I just modified a decree of legal separation the other day because the parties had they had made a mistake in the error, or made a mistake in the calculation of how an IRA was going to be divided. They miscalculated it, and the wife was going to get about $100,000 more than she was supposed to. She's the one that caught it and brought it to our attention, and so we modified that for them later on, and that's done. So some of the reasons: change in income, the children are older, there's a change in parenting time. The kid, especially as kids get older, they might end up living with one parent full time or most of the time. How that's done is through either petition where one party is asking the court to modify it, or stipulation where the parties are in agreement. Either way, everyone has to be served, everyone has to be aware of it. There's two processes for child support modification. The simplified method, where it's just like a change in income or circumstances resulted in a 15% or greater chance. Assuming no one puts up a stink about it, court will generally go through with it that way. But if anyone puts up a stink, it's really not that simple. Then it kind of reverts back to the normal process of modifying the support in any other order. Okay. Modification of parenting time, like we already said, spouse moved, or there's substance abuse or domestic violence problems, not abiding by the parenting plan, remarriage. Every once in a while, have someone come in who wants to change it out of spite, which is not really a good idea, but just some things that can do that. Enforcement. So how do you get the other party to do it when they're not doing what they're supposed to do? These are some of the different things that get enforced: child support, spousal maintenance, parenting time, division of assets and debts. So again, failure to pay support is a crime under ARS 25511 and also Title 13 of the criminal statutes. It's in there as well. Class 6 felony for child support, Class 1 misdemeanor for spousal support. Kind of the process on this is you petition the court and ask them to enforce it. And the court will issue an order to appear at that point. Sometimes they'll do it with you standing there, depending on what's going on in the court. And or if you're doing it in certain courts, you go down to a separate office and they'll give you an order to appear and set a hearing date. And then you serve that order to appear on the other party and along with the petition. And then you appear at the hearing and the judge will say, explain yourself. Tell me why you're not doing what you're supposed to be doing. And the other party who's not doing it better have a darn good reason as to why they're not doing it. So let's see here. Any questions on that? And so some remedies of that, how that kind of works is if it's child support or spousal maintenance, a lot of times the judge will just try and reach an agreement with you. A lot of times they'll have a conference prior to the hearing, actually, with the judge sometimes. That is, they'll just try and get the parties to agree. Hey, this is what I can do. This is why I wasn't doing it. I'm really sorry. Let's increase the payments or something like that. If you can't reach an agreement, sometimes the judge will issue what's called a purge payment. Well, they'll say, hey, write a check for $1,000 right now, or you're going to jail, kind of thing. Where they'll say that, or they might just simply say, all right, there's a good reason for this. Let's just adjust the income withholding order and change how much they're paying, and let's apply some of that to arrears. They might issue civil judgments in the most extreme circumstances where the party is simply just not cooperating and refuse to do what they're supposed to do. Judge could order them to be incarcerated. So, and that has happened. I've seen it happen a couple times, actually. So, enforcement of civil judgments. So this can be a tough one when you have assets or debts that are being divided and the parties are not in agreement on that, or that one of them is not willing to do what they're supposed to do. Judge can't really throw them in jail for that necessarily, for assets and debts. It can be difficult and expensive to collect, but there are remedies for that, and garnishing wages and things like that. One of the other things is when one of the spouses is refusing to leave a primary residence. That can be a tough thing. That actually has to go through the eviction process, even if it says that. So there was a question here from Suzanne. Hopefully I'm saying that right. It's not Susan. If one party refuses to do the parenting class even after ordered by the judge, how would you handle that? Well, generally the court, if the petitioner is the one refusing to do the parenting class, the court won't order the divorce. If they're the one refusing it, then they won't do it. What my experience in the past has been, if the respondent is the one refusing to do the parenting class, then the court will go through that, but they will not allow the respondent to file any motions or petitions or answer in court unless they have done that class. They will not let them dispute it. That's been my experience. I don't know if anybody else has had any different experience with that. But usually, as long as it's not the petitioner doing it, the court will go through with it but they will not allow the respondent to do anything if they haven't taken that class. Let's see here. I want to tell one quick little story. Kind of a funny thing. Now, do not take this as this is what the court is going to do every time, because that's not the case. I'm not even sure this was proper for the judge to do this. We had a client where it was spelled out in there that in the decree that the respondent would convey the primary residence to the petitioner via quitclaim deed or via warranty deed as soon as the divorce, within 30 days of the divorce being complete. Well, 2 years later, nothing had been done. And so we filed a petition to enforce, served it on the other party. He actually showed up in court and he said, I don't agree with it. I'm not doing it. And the judge, this is according to my customer, the judge stood up, looked at him and said, you have 15 minutes to take, because I had prepared a quitclaim deed in case they reached an agreement. And he said, you have 15 minutes to go to the UPS store down the street and have that quitclaim deed notarized. If not, you're going to come back and answer to me. So I got a call. My assistant interrupts me with my client, says, you need to talk to this client. And I talked to her and she goes, do you know where UPS store is around the court? We've got 15 minutes to have this thing signed. And so she runs over there, signs it, and the judge said, okay, that's done. We're over, hand her the quitclaim deed, and that was the end of it. Now, I don't know that was necessarily proper for the judge to do that, but judge can do whatever they want, I guess. and it was kind of a funny thing, though. And so, but don't rely on that. I just thought it was an interesting story. Parenting time, enforcement of parenting time. This is a really sticky subject. This can be really tough to do. Where one of the parties is not granting parenting time to the other one. It falls under the remedies for that, fall under ARS 25414. It's a good idea to read through that statute if that's something that's coming up, because there's some interesting penalties there for not doing it. Teenagers can really complicate this. You know, if it's a 5-year-old, the other party's just saying, hey, you can't have them. I'm keeping them here. I've got them locked in the basement kind of thing, or in their Harry Potter closet. Then that can be an issue where law enforcement can get involved. Teenagers are a whole different story. If you've got a 17-year-old kid refusing to go do parenting time with mom or dad, it's really hard for the court to make them do that. They have the authority to do it, but they generally don't, because it's really hard to, he's a teenager. He can make his own choices. You're not going to go arrest the kid and make him go spend parenting time with a parent he doesn't want to be with, she doesn't want to be with. So something that can be really, really tough to enforce. All right, contested matters. Again, I kind of wanted to get into this more detail, but we're running short here on time and I don't want to go over. But again, contested matters, conciliation services can be a really good option for them. That early resolution management conference, a lot of those can be dealt with in that. There needs to be a resolution statement that's submitted to kind of give both parties what they're at, where they're at, and what they want. Resolution statement, simply just a statement by the parties that says, hey, these are the things we agree on, or these are the things that I want if a joint one's not possible. And so the court has an understanding of where the disagreement is, and they can push forward with that, or they can do private mediation as well. Don, can you maybe speak to some of the mediation services that are available in contested matters where there's, they're trying to modify an order, or there's just a disagreement that needs to be dealt with? Can you maybe speak to what that process might look like a little bit?
Sure. Well, as many of you are probably aware, if in most parenting plans require that parties make an attempt at mediation to resolve whatever the dispute is before filing a petition to modify. And so that conciliation services offers mediation services for legal decision-making or parenting time issues, the purposes of which is to try to help them resolve whatever dispute there is and draw up whatever changes that there may be necessary that they're agreeing to. But conciliation services does other things as well. So mediation is a big part of that, and that process is fairly simple. Someone just files either a pre-decree or post-decree a petition for mediation. Right then and there, the clerk should generate an order to appear, and they'll immediately, assign it to a mediator or conciliator at Conciliation Services. And then the parties just have to serve it a certain amount of time in advance and then show up for the mediation. Both parties are required to come. If somebody doesn't come, there can be a $100 or a $200 fine for non-appearance. Now, right now, it really since COVID started, the mediations are being done. To my knowledge, all conciliation services, with the exception of child interviews, are being done telephonic. And I think that's going to modify into doing video conferences for mediations and the other services that are offered there. But also, just so other services available with conciliation services include open negotiations. Open negotiations are typically, people are usually assigned to do an open negotiation by the judge assigned to their case, and it's similar to mediation. The main difference is twofold. One is that it's not confidential. So as we talked about, during the mediation presentation, mediation is confidential, but open negotiation is not. And then the other purpose of open negotiation is to gather information for the judge in terms of reporting back to the judge as to what the parties say the issues are and what their position is on the issues. So there's a report written after the open negotiation, but during the open negotiation, the efforts are pretty much the same as with mediation, where the conciliator is trying to help the people resolve whatever the conflict is and come to an agreement. And then other services offered by conciliation services include child interviews. I don't know if any of you have had a client that needed a child to be interviewed, but usually it can be younger. Usually it should be a child that's at least 10 years of age or older. Again, the primary purpose of the child interviews is to kind of find out what the kid's take is on what kind of parenting time the child wants to have with mom or dad. But then in that process, there are lots of other questions asked that might shed light on other issues in the matter. But the end game primary purpose of the interview is to get that type of information, mainly what the child wants to do, what the child's preferences are. Now, contrary to popular belief, the child does not have a final say on those type of things. I have people tell me periodically that, yeah, well, my child is this age, and so it's whatever he or she wants, right? And the answer to that is no. It's still always what's in the best interest of the child, but it's certainly in most cases probably the judge is going to give more weight to an older child that expresses what his or her wishes are. But it always is whatever's in the best interest of the child. And your 5, your 7, your 12, your 15, your 16-year-old child doesn't necessarily know what's best for him or her, or is seeking what ultimately is best for that child. You'd be shocked. I hear people tell me their 5-year-old, should be able to make the decision as to whether or not they see mom or dad. So there's mediations, open negotiations, child interviews. Conciliation Services also does parental fitness assessments. If you look on the website, they're going to call it evaluative services. The primary evaluative service is a parenting conference. And parenting conference is a 4 or 5 hour conference where conciliator meets with the parties. Again, this is all right now telephonic, but the purpose of which is to gather information that's relevant to parental fitness, their ability to co-parent, their ability to communicate, or lack thereof. And ultimately, there are basically, I always forget the statute, the 406 statute that, outlines all the considerations the judge has to make, or all the issues that the judge or questions the judge has to consider when making decisions about legal decision making and parenting time. In a parenting conference, the conciliator is charged with asking those questions and gathering that information from each person and each person's perspective. And then also, just like in just about all the other services, the conciliator makes an effort to see if they can help them come to an agreement. So it's a bit of a negotiation as well, but the primary purpose is to gather the information that's relative to those statutory factors the judge has to evaluate, and then write a report to the judge, reporting back on what the people said. And then also the conciliator gives their professional opinion on the reasonableness of the parties' positions, and not always, but usually a recommendation about what they think the judge should do. And then the other services are offered through conciliation services is, of course, parental conflict or the parent information program class, the PIP class. And everybody has to take that, whether you're, if you're for a first order, whether it be a divorce, legal separation, or a paternity related custody matter, or legal decision making, parenting time matter. And then also we teach the parental conflict resolution class, which some parties are ordered to attend if they have high conflict. They're ordered by judges. But does that kind of cover it, Rob? What you wanted me to cover?
Yeah, absolutely. That's good information about how that works, and so I appreciate that, Don.
Okay.
So kind of as we get into more of these contested matters, and that's where conciliation services can certainly be helpful, but some other things just to kind of briefly go over is with contested matters, you got to be real careful. I really do not like doing contested matters because I think it's very easy to run afoul of our ethical obligations to not give legal advice. You can do it without it, but you need to be very careful on how you do it. So if you do, you are going to help a client with contested matter, I think you should be really familiar with family law rules 49 through 65, which really gives the outline of exactly the discovery and disclosure portion of trying to reach, the final numbers for these things, and your client be able to make the arguments that are needed to be made for their benefit. The disclosure rule, what the parties are required to disclose, some of the stuff so those are some of the things that, if you can see my presentation there, those are some of the things that are required to be disclosed to the other parties or to the other party, and so on. The next thing is if you have a party who is just not cooperative, or you just don't trust the information that they're giving, you can use subpoenas to examine the source documents, things like bank statements, wage statements, credit reports, business income information, business records, tax records. All of these things can be subpoenaed. The thing to remember about subpoenas is, number one, there's a cost to you preparing it, hopefully. And number two is whoever they're serving the subpoena on, there's a service fee, and there's also going to be the fee of whatever it costs to process that. When I was a banker, I think we charged $80 to process a subpoenaed information. And so that cost is passed on to the person who is making that request. Some other options that you have in that contested matter, where you're trying to discover information, is what's called interrogatories, which are written questions to the other party, and that they're answered within 40 days under oath. And usually there's no more than 40 questions is what the rule says. There are exceptions to that, and you can look up the rule to kind of get those exceptions. But you can submit interrogatories via formal request and say, I want these answers answered within 40 days. Or they can object, either party can object. If you're just in a contested matter and you can't get anywhere with it, you have what's called Rule 65, which gives the remedies of what happens if you can't get anywhere with it. You can file a motion to compel, where the judge can order the other party to give this information, and if they don't, they can impose civil penalties or court sanctions. In some cases, they could find them in contempt of court. or like I said, you can use subpoenas to get that information if they're just not willing to provide it. We don't see a lot of this stuff. Usually, once it gets to this point, typically I refer them to attorneys to at least get some advice on this at the very least. And so, but at that point, if you're in this position where they're just not cooperative, these are some of the potential remedies that you have. Any input or comments on that or anything like that? Okay. All right. So kind of the last thing I want to touch on here is quadros and what they are. I'm going to kind of give you a little bit of information how they work and what some best practices are to do them. I was kind of surprised to see in Brian's presentation that LP designation does not allow you to represent for the purposes of quadro. That's kind of surprising to me. They can be complicated, but a lot of times they're not. And so let me kind of explain what they are. Quadro stands for Qualified Domestic Relations Order. Sometimes it's referred to just as a domestic relations order. I guess it's not technically qualified until the plan certifies it. But what it is it's required for the division of all qualified retirement plans, 401k, 457s, 403bs, anything that's a qualified retirement plan, whether they're Roth or whatever. It's governed by ERISA, which is the actual term is the Employee Retirement Income Security Act. And that requires that. And so pretty much every qualified retirement plan is subject to this. And the only exception to that is government plans. So this might be the thrift savings plan that's offered by the federal government for federal employees and military retirement. And ASRS, which is the Arizona State Retirement System. This is pretty common with police officers, firefighters, teachers, state employees, county employees, those types of things. Those plans are not governed under ERISA and don't technically require a domestic relations order, but most of the plans require an order from the judge, which is really similar. So I kind of lump them all together. It is usually not required for IRAs. So by IRA, I mean things like held at a bank. IRAs held at like a self-managed investment account held at Fidelity or something like that. There's not an employer involved in it, and it's not a self-employed like a SEP or something like that. So generally, you're going to need these to divide 401ks, 403bs, pension plans, things like that. One important thing to note on this is, especially when dealing with ASRS or any other retirement or employer who offers a defined contribution plan. Now, you remember that's one that you're contributing money to, like a savings account that's being invested, or an employer is matching contributions. That's like 401k, 457, or 403b are the common ones. If they offer that and a pension plan, this is real common with Boeing employees. Pension plan meaning they're getting a certain benefit every month or every year from the plan based on their years of service. That usually will require two separate quadros. I have yet to come across an employer or a plan or a custodian who will accept one for both. I suppose they're out there, but they do require two of them. So it's something you need to be aware of. And it's a question I always ask and say, is there a pension plan? Is there a 401k or something similar? And so usually these plans have model language in place. This is the practice that I use. Is I try and get that model language for them. Usually they have a draft that's already made up, and you just fill in the details. Who the people are, who the parties are, how it's to be divided, how it's going to be dealt with, when it's going to happen, those types of things. But they usually have that language in place. And so Fidelity's probably the biggest administrator of these. So I included in this slide their what they call the Quadro Center, which has a lot of plans that they manage. You can find their model language. You can even submit them online to the plan so that they can administer those directly. And it's pretty easy to deal with, pretty easy to Alternatively, if they're not managed by Fidelity, you can call the HR department or the payroll department of the place you're doing it, or you can call the custodian directly. And the custodian being the person who manages the investments in the plan. I always tell them, explain it to them like they're 5. If you call there and say, hey, I need to get the model language for Quadro, they're going to be like, what are you talking about? Explain it, say, I have a client, I have one of your employees who's getting divorced, and we are helping them prepare an order to the court to divide their retirement plan. And it's commonly called a Quadro. At that point, they'll kind of go, oh, right, that. And they'll refer you to a department, or they'll know what they'll send you some information or something like that. I like to, once it's prepared, I like to get the draft approved by the plan first. I'll send them a copy of the plan with a letter saying, hey, this is what we're looking for. We're looking for you to just pre-approve this and make sure that it's in accordance with your instructions. And they'll come back and usually say, yeah, that's right. That's how we want it. Or they'll say, no, we want this changed or something like that. Once you get that pre-approval back, then we submit it to the court by either petition or motion or a stipulation if the parties are in agreement. Judge, after a few days or after 30 days or whatever time after they've been served, whatever the waiting periods are, will sign the order, which is the domestic relations order. You get a certified copy from the court and you send it to the plan. And then usually at that point, the plan will contact the alternative payee, meaning the person receiving the benefit or the division, and set up a method for them to receive their money or their pension or whatever it is they're getting. These can be time consuming. They can be really easy. It kind of depends on who you're dealing with. Usually my expectation I set with them at 60 to 120 days, just depending on how fast the client gets me information, how fast the plan custodian does it, and what they do. They, like I said, they can be very time consuming, or they can be very simple. Now, this is kind of where I go into this, where I was talking about earlier about the language in the divorce decree and the Quadro, about how these are to be divided. And Mary, you kind of touched on this. You have to be very specific about this. If you say in a divorce decree, or a client writes in a divorce decree, for example, respondent to get 50% of the party's 401k, or let's say 50% of their pension benefit, and leave it at that. That means when that person retires, they are going to get 50% of whatever that benefit is. You have to be very specific in that language, and you should be very careful how that's worded, and your clients need to be very aware of that. Is when their intention might be, they get 50% of what I've earned in that plan since we've been married. Those are two different things, two different phrasings that need to be very careful. And so the phrasing on that might say, the respondent is awarded 50% of their community interest in the pension plan. So if, for example, the person was working for Boeing for 30 years, but were only married to the party for 5 of those years, you don't want the respondent getting 50% of the total benefit. Now, you can do that. Maybe you're doing that to deal with other assets and to provide for an equitable division of assets, but you just need to be very careful how that's worded, because that can really cause some problems. And I've seen it cause problems, and lawyers do it all the time. Judges do it all the time, where it's not specific, and then all of a sudden it causes an issue down the road, and they're either having to go back and litigate it, or they just say it's not worth it, just forget it, let them have whatever they want, and then they're not getting really what they're entitled to. So that's kind of that. I wanted to get into more detail with Quadros, but I just didn't have a whole lot of time to get into that in depth. I spent too much time on that process there. But so if you're looking for more information on that, I can provide you some resources, model language, some other Quadros that we have prepared, so you can kind of see. They're all pretty similar. They're all basically how you want it divided, what percentage, what amount is the person getting, and then a bunch of stuff to protect the employer and the plan to make sure they're not giving away more than what they're supposed to. Lastly, I just want to kind of go over some best practices with this, and then I'll wrap it up. The devil's in the details. Goes back to what I was just saying. Is you got to be very detailed, very careful on the wording, and very careful on the phrasing in these documents, because that can cause some issues down the line. Make sure you have a way to track deadlines and next steps. I use a software, client management, well, it's actually law firm management software called Clio. It's spelled C-L-I-O, called Clio Manage. That helps me kind of manage documents, helps manage deadlines, task lists, client deadlines, client communication, all that kind of stuff. It's a really good software. It's not cheap, but it's really good software. It's called Clio, C-L-I-O. Set expectations, like I've been saying all the time. What's the limitation of your services? How far are you willing to go with the client? What their timelines are, what hearing procedures look like, what happens if one of the parties contests it, what happens if they don't, what happens if there's a problem in a hearing, those types of things. Communicate often with the client, make sure they understand where they're at in that process. And I'm going to skip one of them here and go to the next slide, but I'm going to say, and be aware of the time it takes. These can be much more time consuming than you think. There's a lot of questions from clients, a lot of questions from other parties. So make sure that you have built that pricing into your pricing if you charge a flat fee or if you charge an hourly fee or whatever. And be aware, and don't be afraid to involve others. Don't be afraid to refer clients to mediators and attorneys and things like that. And my biggest thing on this is know a good attorney. Know a good family law attorney who can really give your clients advice if they need to, and give them guidance if they need that, or represent them if it comes to that point where they just need someone to represent them. So hopefully that gave you some good information on family law. If you have any questions or have any concerns, or maybe you're looking for some language or some forms or a way to build forms, I'm happy to give you some information on that. So feel free to reach out via email or phone. And but I appreciate you listening.
Rob, we really appreciate your presentation. It was absolutely excellent. I had just one kind of wrap up question for you for people that, for document preparers that are looking to get into family law. I don't know if you mind sharing, how did you end up educating yourself, getting more into family law?
Well, a lot of it was just simply working when my parents were working here, just a lot of working with them and understanding how to do it. A big process of my education on that was also setting up the software that we use, is setting up these hot docs templates, is I had to go in and review the statutes and review the rules and things like that to make sure that the required language was in the statutes. And that was a big part of it. So that was knowing that, and then simply just going through and reading the statutes and reading the rules. And when something comes up, not being afraid to go in and say, hey, I'm not quite sure what the answer is on that. Let me look at it. Let me look at what the rule says on that, or let me look at the statute says on that, and providing that information to the client so they can make better decisions. But a lot of that is simply just reading and being educated on it that way. Okay.
Oh, great. All right. Well, and then, obviously, and I think you touched on this a couple times, the court website is an excellent resource. I mean, if you've never done a divorce before, but you're an experienced document preparer, I don't see why you wouldn't be able to, immediately, follow all the instructions they have and have success preparing a divorce for someone. Certainly I'd recommend you prepare more than that, but it's definitely an area that people can get into relatively easily. Again, as I always like these presentations to maybe, give some encouragement and hope to people that are looking to maybe expand their services. Certainly family law, in particular divorce, is one that, any competent, I think most competent document preparers can easily slide into. So, all right. So Rob, again, thank you so much. Excellent presentation. I want to make sure, did we get all the questions that were in the chat?
I think so.
Okay. All right. one of the questions was about your presentation, and I know you sent a copy to me. So if anybody's interested, let me know, and I can, send you a copy of his presentation. That's okay, right, Rob? Is that okay?
Yeah.
Okay.
It looks like
All right.
there was one question.
Okay.
From Elizabeth, is there any tax consequence to either party dividing the quadro? No. The only tax consequence to be aware of is if they take the money out of the retirement plan prior to retirement age, there's income tax they have to pay on it. But there is no penalty if they take it out as part of the division of the retirement plan, even if they take it out early, as long as it's done as part of that division. But there is no tax consequence necessarily until they take the money out.
Okay. All right. Nice. I see there's a question. Am I going to post all the PowerPoints from all the presenters? I think Kate included a link in the chat. What I can do when everybody, I'm going to show the third word for the day, the verification word. When everybody sends me your 3 words, if you would just let me know which presentation or if it's all of them that you'd like, and I'll do my best to send you copies when I send you your certificate. Okay. All right. So thank you again, Rob, and so I'm going to take back the presentation and wrap things up and show the final word of the day. Okay. So first of all, I wanted to say thank you everybody for attending. We've had an excellent attendance today, and it's just what I had hoped to be. Again, hopefully by maybe March or April at least, we can do. Oops, I have my video. Hopefully by the end of this season, the season being ending in April, hopefully by then we can do something in person. I would love to get back to doing that more because I know a lot of us enjoy being able to just mingle and talk with other people in our profession. But until then, we will have. I am still planning the webinar for the end of February, which will be February 27th, and there'll be one also at the end of March, and then at the end of April, the last Saturday of each of those months. And I'll be sending out notices for those of you who are interested about who will be presenting, what the topics will be and whatnot. So again, thank you for attending. Here is the third and final word of the day. The word is tooth. So the word is tooth. T-O-O-T-H. So again, please remember, you need to write down the 3 words, send me an email with the 3 words in it, and I will get you the certificate of completion. I probably won't get to sending those certificates out until tomorrow at the earliest, because I send them out individually. But I'll get to it as quickly as I can. Any other questions, please email me. So again, thank you all for attending, but I think this will conclude our webinar. And so I'm going to stay on. You're free to go, but I'm going to stay on for a minute to make sure there's no questions that I need to answer.
Thank you, Don.
Thank you. Okay. Okay, so I'm gonna log off. Thank you everybody for attending. Bye-bye.